Greetings, everyone. My name is AJ Zatola. I'm a partner with Venable. I'm in the IP transactions practice, also one of its co-chairs, and also a member of our advertising law practice. We're delighted to have you here today. I'm joined by my associate, Channing Gatewood. This is the Venable Ad Law webinar series. Our November edition is going to be talking about the ins and outs of understanding data rights and advertising agreements. We've got a fairly robust program for you and a lot to cover. And so we will do our best to accommodate questions at the end. If you have any you'd like to add, please use the chat function. But if we don't have time to get to them or to get to them all, certainly we'll have an opportunity to follow up later. So today in our agenda, we're going to be talking about data, data primarily as an asset class. We are going to address data and the advertising industry, intellectual property categories, meaning what types of intellectual property protection is available for data, particularly trade secret, copyright. We'll talk about patent or other types of property claims, considerations for licensing data, confirming ownership, setting scope of use, setting restrictions. And then finally, because it is so important to data in the advertising space, we'll be addressing privacy implications, but only briefly. That is in and of itself a larger topic, and our Venable team also has a lot of materials or resources on privacy as well, and we'd encourage you to look at those if you have follow-up privacy-specific questions. So, current trends in the data industry, we don't wish to suggest that data hasn't been used for advertising. It has been used for advertising for decades, but increasingly, particularly in the online space, it is part and parcel of targeting and most marketing outreach and focused advertising efforts. And so the sale and licensing of customer data is increasingly valuable to advertisers. And being able to designate ownership of this valuable asset class needs to be managed accordingly. And there need to be careful considerations for how data is licensed or sold and how data can be managed. There are legal compliance needs, protection needs, et cetera. So restrictions are also an important element of these transactions involving data. So data as a business asset is today a part of the business property. It is a property class that should be separately considered as such, although it is related to intellectual property and has intellectual property protection, simply because data by itself can be an asset of great value. For many advertising businesses, this sometimes is their key asset. And so it's important to think about how data can be protected, how it can be exploited, and how it can be managed. And we're going to go through each of those now. First, we're going to talk about the available protections for data as an intellectual property asset. And not all necessarily apply. Before we talk about the first one, I'm going to note that generally speaking, when we're talking about data, we're largely talking about factual data. And so there will be limits under US intellectual property laws as what kind of coverage is available. Moreover, this isn't the kind of IP class for which trademark protection really applies. So we won't be separately addressing that, although certainly data can be branded as a product offering or a service offering. And it's not to dismiss trademarks, they're just not typically a body of law that will apply to the data itself. You're going to have a brief overview of the asset classes, and then I'm going to have Channing lead us through some of the considerations. So specifically for data and protectable asset claims, we're going to have discussion about trade secret protection, copyright protection, briefly touch upon patent protection, and then highlight some available property claims that might also attach to data.
Great, thank you. So yes, as AJ stated in the previous slide, data may be, or factual data in particular, may be protectable as an intellectual property asset. And that's in addition to the protection that data already may have via the terms of a contract. So for example, via the contract's confidentiality provisions or restricted use language. Protection of the data as an IP asset, however, may provide a little bit of a firmer form of protection than protection via contract terms, because protection via IP invokes federal law. So again, may provide a firmer and more enforceable form of protection should the rights associated with the intellectual property asset be violated. So specifically, as AJ said, data may be protectable as a trade secret, copyright, patent in some cases, or intangible property. So to ensure that the data as an IP asset, regardless of the category of IP that it falls into, the data owner should, one, secure a clear chain of title for the data asset, meaning, for example, if the company owning the data has engaged other parties to manage, handle, otherwise compile, or organize the data, that presumed data owner should ensure that it, as opposed to those other parties, is the ultimate owner of the data and the rights associated with it. Also, that data owner should, as just said, consider the categories of IP that may apply to the data and make that determination. Also, that owner should ensure that the language of the licensing agreement aligns with the particular IP category that the data falls into. And lastly, for the purposes of this list, the data owner should set up and review its internal security systems and controls, as well as ensure that when it enters into agreements with other parties, those other parties are required to maintain certain security systems as well. This is particularly important in the case of data being protected as a trade secret, which AJ will be discussing next, because efforts to maintain the confidentiality of the data is a requirement for the purpose of maintaining trade secret protection.
Thank you, Jenny. So trade secret law is probably the best or most protective way you can cover data rights. And we're going to talk to you a little bit through trade secret protection. This is all background, so there isn't anything unique here to data as an asset class, but it's important to highlight that not all data is subject to trade secret protection. The trade secret protection is generally under a Uniform Trade Secrets Act that most states follow. There is a federal law now that has a comparable definition, but for purposes of consideration, I think this definition is sufficient. For data to be a trade secret, and that's entitled to trade secret protection, it has to be something that has independent economic value, generally because it's not known. So it's a secret, so to say. In addition, it needs to be subject to some reasonable efforts to maintain its secrecy. So you need these efforts and you need to have the data be of this type in order to claim trade secret protection. Without this, you would not be able to make a claim. So not all data will qualify for trade secret protection. Not all individual records will qualify. Typically, it's easier to manage this as an asset class if you treat things by database, because the larger database more easily fits into this definition. And we're going to want to have this definition hold in order to be able to protect the data as trade secret. So handling data as a trade secret and to maintain that trade secret status when you're doing that in your transactions requires a little bit of initiative. You're going to want to undertake certain efforts in order to maintain that trade secret status, that secrecy, so to speak, through the transaction process and with the recipient or the licensee. And so your agreement really needs to address a couple key components as it relates to trade secret protection. There's a need to limit the data. So theoretically, this should only be data being provided to need-to-know employees. Your agreement could state as much. There needs to be some way to have the recipients who are receiving access, the employees, be bound by confidentiality restrictions. So when you're thinking about this type of control, your agreement not only needs to account for confidential treatment by the contracting party, but also that the agreement itself speaks to binding the employees themselves. And then you need to have in the agreement evidence that there are systems or measures in place to manage or address unauthorized or improper disclosure of the information. All these things taken together are ways to maintain that secrecy, show that secrecy, because if you're in an enforcement setting for a trade secret misappropriation claim, you're going to have to prove this. So you're going to have to show both that the data itself met the trade secret definition and that steps were taken to maintain it as a trade secret. So your agreements really need to try and address these elements. It's important to also appreciate that what we're describing to you here is specific to addressing trade secret protection. There may be additional needs to have similar types of security clauses, provisions, measures, etc., for personal information. Oftentimes there can be overlap. Unfortunately, certain types of personal information won't qualify in and of themselves as a trade secret. A phone number or a name or an address typically won't meet the trade secret status because that kind of data can be found out. On the other hand, having an aggregate database of records might. And so your agreements or your measures already might be accounting for things you need to do to protect personal information. But keep in mind that you also need to think of the data as also being a trade secret for which additional measures may be necessary.
All right, thank you. So next, we'll be discussing copyright protection. In addition to protection as a trade secret, as AJ discussed, data compilations may be protectable as a copyright asset. So first, as a quick overview on copyright law, note that federal copyright law grants the copyright owner various rights, including the rights to make copies of a work, to perform it, distribute it, or prepare derivative works of that work. A work generally will qualify for copyright protection if it includes a minimal modicum of creativity, as well as is fixed in a tangible medium of expression. And as a difference from trade secret protection, copyright protection is limited in terms of the duration of the protection. So for a corporate author or a business entity, for example, copyright protection will last for 95 years from the date of the publication of the work or the date that the work is made available to the public generally, or for 120 years from the date of the work's creation or the date that the work is first fixed in that tangible medium of expression, whichever date occurs first. Go to the next slide, please. So again, copyright protects data compilations as opposed to the underlying data itself. I'm emphasizing compilation because the underlying facts of the data compilation, so the data, cannot generally have the sufficient minimal creativity that is required of a copyright asset. Because frankly, the data is not creative, it's a fact. However, a particular arrangement of the data is more likely to satisfy that requirement. So if the data is selected, coordinated, arranged, et cetera, in a particular way, that creativity standard is more likely to be met. The standard is generally pretty low. So most compilations, including data compilations, will meet that standard as long as the owner played a part in the organization of the data. However, the standard does need to be met. So if a company is unsure if its data arrangement satisfies the minimal creativity requirement to be a compilation, of course, they can work with counsel to answer those kinds of questions.
We'll talk briefly about available patent protection, and obviously laws can evolve, but currently there is not really much protection under the patent laws for data or even for the database itself. This doesn't mean that there couldn't be associated processes or certainly algorithms or other types of associated inventions that may have patent protection or may be available subject to the typical patent standard of novelty and non-obviousness. But the data itself, the database currently, patent protection isn't really going to provide much for you. So we'll sort of re-emphasize the need to look to trade secret law to provide some measure of protection. And typically the practices that you would otherwise be implementing to maintain that trade secret status will be useful for further patent considerations down the road should the laws change. Beyond intellectual property, there have been instances where case law or common law has tried to treat data as a property class or other types of property and tried to implement or use traditional tort or real property principles and common law claims to provide protection. Trespass to chattels has been used to try and provide protection or in an enforcement setting with respect to data or databases. Conversion is another concept that has been used with data. These types of claims are going to vary by state, but it is worth emphasizing that depending on the state that you're in, some of these more traditional types of legal principles may apply and certainly are worth evaluating depending on the circumstances. As it relates to your agreements and how to sort of incorporate these concepts into your handling or treatment of your data, again, it gets back to having measures in place and document them showing that you made the data available on a restricted basis so that when unauthorized access occurs, you may be able to seek remedies under these broader types of claims. We're going to talk next about data licensing agreements. I'm going to pause right now to provide the CLE code for this presentation. It is Data Rights 2022. Again, the CLE code is Data Rights 2022. So we're going to get into data license agreements. Usually, when you see data in the advertising space, it is typically a part of an agreement. It may not necessarily be characterized or entitled as a data license, but oftentimes will be attached to or incorporated or integrated with a larger service arrangement or product offering. So when you think about the data license agreement, that doesn't necessarily mean that it's a standalone data license, but these things we're about to talk about are certainly relevant when data should be a part of the arrangement, whether that be service or other type of product offering. And you can certainly incorporate the types of clauses that we'll be considering as it relates to data agreements into larger agreements, your larger customer retention service arrangements. We're going to primarily be addressing these topics from the licensor perspective, but certainly it's fair to look at these things and think about them as a licensee as well, because oftentimes your licensee considerations for some of the same points will matter as well. Before we get to the data license agreements, we're going to pause and highlight that before there is any exploitation of your data, you need to make sure that you've nailed down the protection first. So go back to the IP discussion we just had and the topics we covered to make sure that you've considered available IP protection. But once you're ready to have a data licensing agreement, we're going to talk a little bit about what are the kind of key considerations for your data arrangements.
Great. So just starting with our data licensing overview, there are various reasons that a licensee, so the other party, may want to receive a license to the licensor's data. Reasons may include wanting to use the data to provide certain products and services to its customer base. The licensee may want to enlarge its own data collection, or it may even want to license the data to which it just received a license to another party. So there are various arguably valid reasons why a licensee may want to receive that data. Ideally, however, the data license agreement will also keep in mind the licensor's interest, so the company granting the data license, as well as the interest of data subject, which we'll discuss more a bit later, but the individuals whose data is being collected for the transfer. Those data subjects will also likely want to ensure that their data is kept secure. And so the agreement should acknowledge those interests as well. Go to the next slide. Okay, so as a data licensor and licensee or third party are preparing to execute the data license agreement, it's important that the agreement expressly acknowledge a few things. So one, the agreement should acknowledge that the licensor is and will remain the owner of the data. This is, of course, to confirm that the agreement one is a data license as opposed to a sale or other complete transfer of ownership and the rights associated with that ownership. Additionally, the agreement, the ownership language in the agreement should align with the category of IP that the data falls into, so similar to a point we made earlier. So for example, if the ownership language emphasizes that significant resources went into collecting, amassing, organizing the data, that language would support the data being protectable as a copyright asset and making it more evident to the licensee that the data is protected as a copyright asset. And lastly, for the purposes of this list, it is in the owner's interest to narrow the scope of the data. So narrowing the scope, which may mean excluding from the definition variations of the data, modifications of the data, derivative works, et cetera, so that the definition stays narrow. Doing so that the definition only includes what is necessary for the services or for the purposes of the license relationship. It's sort of a risk aversion technique. So it minimizes the opportunity for the licensee to incorrectly use a large quantity of the licensor's data. Unsurprisingly, this will probably be a negotiation point between the parties, as the licensee is likely to prefer that it receive a license to use a greater quantity of data as it wishes, but the licensor's interest should certainly be considered in that situation.
Next, we're going to talk about data use. This is a critical element of any data arrangement, and unfortunately, one area where we have not seen enough clarity, and that has led to problems. When you're dealing with data use, there are different ways to handle this. If the arrangement is somewhat standard or there is a standard offering, it is certainly appropriate to have standard terms that are incorporated into the main body of an agreement or as a part of a standard grant to use. But in a lot of arrangements, that is probably not going to be the case. And so quite often ancillary documentation is used with respect to defining appropriate data use. And that's fine as well. But within the need to articulate what data use is permissible, you really have to dive into the details. Depending on what protection is available or what you're making available, it's really, really critical to have specificity with the data use. What data is being provided, whether or not there's any updates to the data, and then what can or cannot be done with the data. It also is important to consider that what was permissible or described as a typical use practice at one time in the past may no longer be the typical use practice of today. We certainly are seeing an evolution in the privacy space over different types of data collection, sharing, and regulation with respect to both. So what was permissible in the past may no longer work anymore without certain additional compliance needs. So your data use really needs to be specific. And we have seen a lot of ambiguity with respect to these use cases. So you really want to have much granularity as you can have on what rights are being granted. And at the same time, you need to be specific over what limits exist. These are not restrictions, these are limits. These limitations could be medium, channel, industry, territory, user. They also can apply because of regulatory needs. There are certain things that data can or can't be used for, perhaps. And so you really need to spell out both. And we would advocate for having a data use description or data use limitation specifications that are sort of current with the agreement and that they be updated in a more real-time basis. What you see oftentimes with some of these things is that there's sort of ongoing provision of terms because the database changes. So don't be afraid to look to that evolution on the data use description as well, because this is really what determines under the agreement what you can or can't do with the data. And if you have ambiguity here, it can lead to problems. Also appreciate that the perspectives of the parties to the contract, and we'll generally say as a licensor or licensee, are going to vary. What the licensor is looking to do, as we've been sort of highlighting, is to protect or to limit the data. On the other hand, the licensee likely wants to exploit and may have other things. So at the end of the day, your terms really need to be specific. And if you read the data use description and it's subject to interpretation, then we would advocate that you go back and try and provide more specificity. It is certainly useful sometimes to have illustrative examples if general terms will not do it, but you're going to want that detail. Within or related to this conversation is the notion of license scope and license restrictions. So previously, we're talking primarily about what you can or can't do with the data, and even with permissible usage, whether there's limitations. But oftentimes, there's going to be a need to define who else can use the data. Are you working with an entity that will have contractors, volunteers? Is this an entity that has affiliates? Is this an entity that works for its customers, where there goes to be a downstream need to, in a sense, resell the data? So sub-licensing is an important consideration. Then, what can you do with the data? It is certainly appropriate in these circumstances for the data grant to be use only, but a lot of times the data will be used in a way where it leads naturally to derivations or even possibly changes. So you need to specify what is expected or permitted behavior in both respects. And then tie back to the data uses, are there particular purposes for which the data should be used? Is the data being used for internal purposes only, for analysis purposes only, for research purposes only? Or is the data being provided so that can then be further exploited by the recipient or the licensee? It's necessary to spell these things out. Data laws or related data laws tend to be national in scope. There are no worldwide generalities at the moment. And so even though data is an intangible asset and something that can easily cross borders, you still need to think about territorial use, territorial limitations. Use only within the United States may have different rights, laws attached to it than use in Canada or Mexico, or especially in Europe, where there can be a number of differences. So your license scope needs to consider where the data is being used. Depending on the business terms, there may be a need to define an exclusivity arrangement. So these restrictions or these scope limitations can also be used in that respect. And then as it relates to the sub-licensing rights, you need to kind of define who the authorized user is. Is it an employee? Is it a contractor? Is it both? Are they working on their own behalf? Are you giving this to clients and their employees? So you'll see a lot of need here to get into the specificity of what you can or can't do with the data. And unfortunately, a lot of times the agreements don't do this. You have a basic grant or extension of permission from one party to the other without this detail. So you're sort of left in the dark about what to do with these things, and that can lead to problems down the road. We want to talk a little bit about differences in original versus derived data. Now, appreciate that in a lot of arrangements, it will be use only. So what we mean by this is you're receiving access to the data with no allowance or permission to make changes to it. And so that is, quote unquote, just use of the original data. But what is the original data? That can be difficult to define. I would also say that notwithstanding what we're about to share with you here, there can be complications, particularly in the ad world, where there's going to be overlap. Oftentimes, what you're looking for is data that has value because it can be used to sell products and services. So you're often talking about different attributes or qualities of data with respect to a single individual. And everyone might be keeping a so-called record in some respect, or a profile or a graph about that individual, and already have in place data related. And so what is original data here is really just a term to define what data is being provided. It doesn't necessarily mean that it originated with the data provider. And if the recipient of this original data already has the same or similar data, that is a consideration to work through. For better or worse, data is not the kind of category where the content, except originality akin to what you see in the patent world, is easily defined or created. Moreover, as we've been explaining to you, although data can have copyright protection, that tends to be for larger bodies of data or aggregated data. So individual records have very limited copyright protection, and unless they're being treated as a trade secret, there is a very limited recourse to stop someone sometimes from using individual records, particularly if you already have those records. So we would suggest that there be clarity here, and then for the recipient, there be clarity on what data they might already have. This can be done a couple ways. You need to be specific as to what you're providing and when it's being provided, in what format. Another way to deal with this notion of what is original versus derived is to sort of specify how the data can be received and then further managed and stored. Can it be incorporated in other databases? Can it be stored in one location versus another? Can it be separated? These are all ways that, although are getting back to describing how data can be used or not used, can also be used as a way to maintain the integrity of what is original. Almost thinking about this as handing over a file. If you give the file, you expect the file to come back. Now, then what is derived data, since we've been talking quite a bit about original? This is essentially talking about what can be generated or derived from the licensed data. That can be a lot of things. And frankly, all of that might be separately protectable or claimable by the recipient or the licensee. In terms of visualizing this, really think about this as the new data that's being created or generated from the older data. So it doesn't copy the older data, but it's new data that naturally results from the processing or the leveraging of the exploitation, et cetera. What falls in the derived data category? That can be a lot of things. It can be analysis, it can be a data that's appended, it can be data that's added, it can be data that's changed. Those are all possibly categories of derived data. How best to define what it is really gets back to defining what that could be and accounting for it as something that the agreement itself generates. And appreciate, though, that what you're doing here with derived data is possibly giving right to new ownership claims by the recipient or the licensee. And as to whether or not the original data owner should own that derived data, that is something for the parties to work through. There's no mandate that the licensee or the data recipient can't own its derived data. And oftentimes the licensee or the data recipient is in the business of data. And so they want claim of ownership or they want control over that derived data. So if this is of concern, the data recipient needs to be thinking about terms to address this. Don't just rely on the data provider, the licensor, the supplier's agreement. Account for ownership claims or rights to that derived data. There will naturally be a need to work through the scope, but at the same time, it's important to make that claim in writing so there's clarity there. And ownership can confer a lot of benefits. It allows for enforcement, it allows for possible legal remedies, subject to the ability to also make those IP claims. And it also has some detriments. As the owner, you're naturally going to have more compliance responsibilities. The law will look to you to comply with privacy law, et cetera. You will not be able to say, oh, I got the data from somewhere else if you're simultaneously claiming it as something that you own. And so sometimes mere license may be better because there might be opportunity to allocate those responsibilities to the provider originally. But at the same time, if you're looking to separately leverage your derived data, then maybe you want to own. Also appreciate that sometimes the derived data may not have much utility apart from the original data. Really going to be dependent on what you're talking about. So some of this might be theoretical, but at the same time, it is still important to think about. And with this class, although trade secret rights can survive in perpetuity subject to you maintaining them as trade secrets and the data having value, at the end of the day, data in the advertising space oftentimes has limited time value. You kind of want what the consumer, the individual, et cetera, is currently thinking about that day, and you want current information. It is of no use to have an old address or old buying habits. People's habits or data associated with individuals may change with age, et cetera. So even though we're talking quite a bit about claiming ownership or determining what permission or licensed use should be extended, at the end of the day, there may not be always a long-term need. And so this is just another way of saying that sometimes a license is okay, or sometimes the data has temporary value such that you can treat it as a temporary resource or asset class. We mentioned that it's important to specify what data is being provided. So what is the original data? You can do this in part with a more detailed description of the data delivery. This is another area of the contract that tends not to have a lot of detail in it. So I think it's always useful to explain how the data is going to be provided. When you do that, that can also assist with certain privacy implications, or you can use the agreement to highlight that the transmission is being done on a quote unquote encrypted basis. So how will it be delivered? Then when will it be delivered? Are you providing it once, monthly, etc.? In what format? This can assist with maintaining the integrity of the data by the recipient. It can also maybe limit the ability to misuse the data because you're providing it in a format that can't be as easily changed or altered. On what technology platforms? This can relate to pricing, how frequently. So all these elements are details that really ought to be specified. So beyond just going through what data will be provided and then allocating or addressing what happens to the data if it is allowed to be derived or modified, we would really advocate that there be more detail on the delivery itself. And you may be able to implement a fair number of controls here if you have tight controls over the delivery. A lot of times it's going to be electronic and password protected. And so that kind of limited access usually will give rise to measures or highlight measure that's used to keep the data secret. So you can see how some of the things we're talking about as considerations for your agreements also can relate to showing or demonstrating that you maintain the data as a trade secret. Now we're going to get into the privacy implications, which Channing will lead. I want to emphasize this is not a deep dive. Moreover, there's going to be a number of changes being instituted in the United States, in particular for next year, that require probably a little bit more detail. Certainly the Venable Privacy team can assist with that. But just think of this as a little bit of an overview to tie into some of the intellectual property concepts that we're talking about.
Great, thank you. So yes, a party's development and use of data may implicate certain privacy and data protection laws relating to its use and disclosure of personal information. So that's what we'll be discussing in these next few slides. So while being on the receiving end of a data license can be beneficial to that licensee, for example, the licensee may be doing so because it wants to avoid having to gather and arrange data itself, the licensor is then faced with some risks surrounding the security of the data and if its disclosure and use of the data will be in compliance with certain data protection or privacy laws. Just as a visual example of that, if a company A licenses its data to company B, the data subjects of company A, so again, those are the individuals from whom the data is collected, their data is now subject to the systems that are in place at company B. Company A, however, could still be held liable in the event that the data subject data experiences a data security breach or there's some other major compromise of data at company B, because the data subjects gave permission to company A to use their data, not company B. So the relationships can get a little bit intertwined and complicated. So when entering into these kinds of relationships, the licensor or the company A in that scenario should do proper diligence of the other party or the company B, as well as also review its internal systems and compliances with applicable laws, just to lessen the likelihood that it will run into some legal and regulatory complications. Next slide, please. So now focusing on some of the legal and regulatory considerations a company should make when handling personal information. So personal information, as opposed to just data, is being emphasized right now because the use of personal information as a category is pretty regulated due to various concerns including concerns regarding the protection of children and their personal information online, identity theft, as well as security of health or financial records, to name a few. The definition of personal information as a term, however, can vary, sometimes depending on the state, the jurisdiction, the actual policy that defines the term, or even the terms of an agreement. It may be defined within a contract. There's not one central definition. However, the term tends to be defined. There does tend to be a general definition that doesn't differ too much from jurisdiction or to agreement, as you can see on the screen. So information that could reasonably be used to identify a data subject or individual, including name, address, email, social security number, etc. Or a combination of those. We can go to the next. So there are a variety of policies that may apply to an organization that transfers personal information to another party. So to determine which laws may apply, the company should consider a variety of things, consider what individuals are affected, what type of information is being collected, where the parties are located, among other considerations. And the answers to these questions will determine what policies may apply. Some of the policies an organization may want to consider are on the screen. This is just a sample, so it's not an exhaustive list, but it does include a mix of some location-specific policies, industry-specific policies, as well as policies that concern certain individuals. So just to highlight a few, one example on the screen of a location-specific policy is the General Data Protection Regulation, or GDPR, which requires businesses to meet several conditions before or after processing personal information of customers in the European Union, such as certain destruction or storage requirements. An industry-specific policy on the screen is the Federal Gramm-Leach-Bliley Act, which requires financial institutions, so it's specific to the financial industry, to ensure certain protections of its customers' personal information. And as an example of a policy that applies to a particular set of individuals on the screen is the Children's Online Privacy Protection Act, which requires hosts of commercial websites to comply with various requirements when managing the personal information of children, such as requiring certain consents to be obtained from the parents of those children, particularly for children under the age of 13. The next slide, please. So as you maybe can see, the lack of clarity surrounding the details of personal information collection and use can cause a company to unintentionally violate some of the data protection laws that apply to its activities. And a company can put itself in a better position to ensure compliance with some of these policies by doing a few things. One, it can complete an internal security risk assessment, so an internal assessment to identify some of the security weaknesses within that company. The company can also determine what types of personal information it's collecting and from whom, because as just discussed, different laws may apply depending on that answer. The company can examine how it's collecting personal information. So is it collecting information online, via mail, in person, publicly available sources? Again, that may implicate different types of laws. The company should examine its own actual use of the data. So asking questions as to how the data is actually being used, or the personal information, excuse me, is actually being used. Is it being used for business development, licensing out to other organizations for particular industries? Those answers also may implicate certain laws. And lastly, the company may want to examine its own storage and destruction practices for the personal information. Where is the information being stored? How is it being destroyed? And what laws are implicated by those activities? All these considerations and others will help the company that's collecting the information evaluate its compliance with various laws.
This slide is entitled Setting Privacy Standards for Vendors, but you can also replace the word vendor with licensee, recipient, contractor, etc. Essentially, what the slide is asking you to do is think about what standard for privacy, or really data handling, compliance, management, etc., are going to apply to the entity that is providing the data, and then also the entity that's receiving it for use. And there may be a need for consistency, or at least a consistent approach. But there also might be times where each party will have different roles and responsibilities as it relates to this topic. Note that as a data owner, you are going to own the data compliance role. So this is not something that can be avoided. As a consequence of that, there are certain standards that apply when that data owner gives the data to someone else. You can't ignore your responsibility simply because another data recipient or data licensee or another party, frankly, is controlling the data at that point. You need to maintain consistency. This can be especially true with respect to privacy considerations. So we would suggest that there always be a diligence process on the recipient, the vendor, the licensee, the contractor that is implemented in a standardized way. This diligence responsibility is likely going to involve not just legal, but other types of security considerations, particularly information security. Don't be afraid to get your IT involved here. The technical aspects of how data is being transmitted, stored, used are equally important, and also almost a separate category for compliance, usually with certain types of certifications, or even with respect to the provision of the services. The government in particular has a lot of rules over how data can be accessed, stored, etc. So when we say diligence, we don't just mean legal. Really mean the entire company is a steward for the data. What are they going to allow or not allow, and how are they going to manage the recipient? Develop standard contract terms that support this, that touch upon privacy needs, security obligations, etc. Oftentimes you can use an addendum here, a data security, data privacy, data processing, an addendum, something similarly titled, can be used to fulfill this role, but you can also begin to implement these in your standard contracts. In Europe, by contrast, there are some sort of national level forms that are used for this purpose, and they have been blessed such that they can be universally accepted. And you'll see that sometimes show up in the United States as well. But bear in mind that even though adherence to those terms is sometimes required, it isn't because of US law. So it's sometimes better to have separate treatments in the United States, and even between the US and EU, there might be a need to maintain some consistency. So have some standard terms, both as a recipient and as a licensor. You'll need to engage in regular oversight. This is not something to sort of set and then forget. Remember that you are the steward. And so if your recipient or licensee is engaged in conduct that is involving misuse or may lead to unauthorized access, there can be an upstream responsibility. And so you're going to want to have means to review, monitor, audit perhaps. Think of this as just good practice. You'll probably need to incorporate other policies into allowing others to use your data. And so again, back to the point that you're going to have to be thinking about this more broadly with your risk management or IT teams or your privacy policies. Those things may play into it. You may be in a position where you can leverage some of your existing frameworks or policy approaches for other types of IT software hardware usage, things that you developed in the past, even for your own employees. You may want similar practices or policies followed. Note that you don't always have to give them verbatim your policy documentation to follow. It is appropriate sometimes to have or call for something substantially similar. Moreover, you can leverage industry recognized programs or certifications that also call into play these types of standards as a way to demonstrate compliance. That sometimes can be an easier way to do it. And frankly, within the advertising space, there's been a real call in the industry to try and develop standard practices such that it's not always the government saying what you can or can't do. Well, unfortunately, as we move into 2023, there are going to be new state laws, all perhaps with differences, sometimes subtle, that are still going to necessitate internal policy measures and approaches. Implementing a privacy policy is sort of separate but related to a lot of these topics, because the privacy policy is what you're telling the public you do with the data, what is collected, how it's being used, how it may be shared. So when you're thinking about your data agreements, it is necessary to maintain consistency with your public statement. Usually when there is enforcement associated privacy policy, it's because the privacy policy is inconsistent or flat out false with respect to what you're actually doing. And so you need to think about the two things and try your best to sort of marry the practices so they are consistent. This can mean a lot of different things. It can mean that you are requiring someone to follow the policy that you post. It could mean that you're requiring someone to follow a more focused policy approach for a category of information. You'll see this quite often with those laws or standards that apply to data with respect to children being under the age of 13. And you also may have need to sort of emphasize that the data recipient has to have its own policy. That there's no requirement here that you have to always mandate what the other party is doing. Moreover, privacy policies are really about a company's own data collection, use, and sharing practices. So it would be impractical in a lot of situations to have one entity dictating, but there is a need to sort of think about this in terms of how it relates back to your data sharing, because if you're giving away data that is inconsistent with your privacy policy, that's going to lead to problems. Managing your practical, let's call this the practical privacy risks, speaks to what are the practical risks that you're going to see, what actually leads to loss of data, unauthorized access to data, etc. Usually this is your work devices, and in many cases your employee habits, although you're going to want to think about your contractors as well. You're going to want to have controls over where data is stored, where it can be used, whether that be laptop, internal network system, mobile devices, etc. You need to think about how data can be transmitted. Is it through email, etc.? Can it be stored separately on physical files? If you tie this back to some of the things we were talking about in the data agreement about having data license, data use, data specificity as to both, you can also think about how this relates back to sort of managing the privacy risks. A lot of data is lost, sometimes just merely by mere negligence or mistake. Something stored on the laptop that gets left in a taxi. So you need to think about these things in your agreement as a way to perhaps have some restrictions. Don't send the data one particular way. Don't store the data on this device. Don't take it off the system. These are ways to manage your privacy risks and also manage your data use under your contracts. There is available insurance for data privacy. At this point, this is something that everyone should be evaluating. Scope, coverage, cost varies, but it's prudent to have insurance because the risk of data loss is quite prevalent. And frankly, to be honest with all of you, there is no guaranteed security. Data theft or an intrusion can happen to anyone, even with the strictest of controls. So when you're managing privacy risks, what you're really talking about is managing the risks. You're not preventing privacy incidents from happening. And the insurance coverage is a backstop for even though prudent managing risk was occurring, still things can happen. The more sensitive the data, the more valuable the data, there may be need for enhanced security. It's also important to emphasize here that when you're dealing as a customer now, as someone who is using another product, receiving or giving another entity your data, there may be instances where the associated platform, cloud service, SaaS, etc., doesn't have adequate security. A lot of standard agreements out there may have very limited responsibilities for security. And so you need to take those things into consideration because sometimes that means that the system, et cetera, that you're using isn't appropriate. But that doesn't mean you can't use it. It just means you need to manage around it. Perhaps it's not used for storage. Perhaps you use it for particular categories of data. It's also important to think about as we tie this back to what data you're providing is that not all data has the same level of risk. And frankly, within the advertising industry, there is a lot of effort put into exchanging data that may not have the same responsibilities. But at the end of the day, the value of the data often is tied to an individual. There's an increasingly broad spectrum of data that constitutes personal information these days, certainly broader than 5-10 years ago. So even though you might have risk levels to your data, and even though you might not be dealing in data, you still want to think about all these categories with respect to everything that you're doing. Personal information in advertising, at the end of the day, the two things might also mean the same thing these days. I mean, advertising might be personal information if you really think about it. Technology is changing. We're kind of undergoing an evolution here, seeing evolution away from cookie-based collection to other types of collection. There is increased enforcement and scrutiny, particularly by the states. You're going to see a lot of movement here. The need to interact with your customers over this is becoming important. There are opt-out regimes, not as many opt-in per se. So this is definitely something where you can use the data, but you might have more compliance needs than you had before. Again, this is a much more separate topic that you'll need to get into with our privacy team. Happy to help with that. But, I think advertising really is built on handling, managing, using data, and the privacy implications go with it. So this is something that you're going to have to be thinking about. I'm going to try and get to a couple questions simply because we're running out of time. But to recap, best practices, perform due diligence. This needs to be part and parcel of your data arrangements going forward, whether or not you view your business as being one built around data or you're simply using data. Everyone has data now. The data has value. Develop standardized practices, contract terms, etc. Leverage insurance if you can. Regularly review. The scrutiny applied to whether or not you're appropriately or negligently handling data is really built around whether or not you have assessed the possible risks and taken steps to mitigate or manage or minimize them. So you want to have an audit process, review, et cetera, so that you can use that. And finally, we talked a little bit about all the various categories for protection. That's the best way to have an enforcement mechanism later. And your document should be specific so that if you're trying to address specific conduct that you deem inappropriate or unlawful or misuse, your agreement's already made the necessary limitations so that that's easy to manage. So we've got a few minutes left. Let's see if I can figure out various questions. By the way, we'll have follow-up with our email here. So if we don't get to something, do reach out to us. The first question I see is how to account for changes and what is acceptable. Typical is there language the licensor can use for those scenarios? Yes, there is. There are different ways this is received. It's sometimes a good practice to point out that your handling responsibilities, your processing, et cetera, may change with time or with law. So that is something to get in as an allowance. But you will certainly encounter counsel that don't like having changes introduced. So another way to deal with this is to try and attach to your description of the data what is acceptable, so that if you're updating what data is being made available, then you can provide to it certain handling responsibilities that go along with that data. That's sometimes easier. So another way of stating that is that rather than having a standardized grant and a general description of simply an agreement says we're going to provide data, indicate that the data will be specifically laid out and set forth with particular handling responsibilities on orders that will be specific to a time period. So that is an easier way to introduce some of these conditions because it's sometimes hard to manage the master contract that way. Let's see, are there risks from the perspective of the subject to grant the licensee data recipient using anonymized data? There are less risks if the data is truly anonymized. It won't qualify as personal information and you may have fewer responsibilities, but that doesn't mean that the data doesn't have value. So if you're charging someone for use of valuable anonymized data for whatever it is, you still want to manage it the same way. It's just that you might have less regulatory compliance needs. I will also say that a lot of times when people think something is anonymized, it truly isn't. The laws are also getting broader. So what was personal information 5-7 years ago may no longer be, or what wasn't personal information 5-7 years ago may be personal information today. But I would just say same treatment no matter what, but you can be a little bit less strict with anonymized simply because it tends to have fewer regulatory responsibilities. Let's see. Privacy standards could be challenging with social influencers. Influencers may not be adept with the data. How would you address? May need a little bit more clarity on this. It's difficult for me to assess. One thing to point out with social influencers, you are typically influencing through a platform, which is going to have its own rules that dictate what can or can't be done with data on the platform. This would be Twitter, Facebook, Instagram, etc. So whatever is happening is going to have to be consistent with that data. And from an advertising perspective, I mean, there's a lot of things that go into leveraging that data and engaging in, actual advertising and what your roles and influencer might be with respect to that. But we might need a little bit more clarity on that one, so we can, if we didn't properly address that, we can handle it better. Let's see. Share examples of data compilations may be considered for copyright. There's no bright line test here, but the traditional example is the phone book. If the phone book is in alphabetical order, it will not be considered sufficiently creative to qualify as a copyrightable protected compilation. On the other hand, if you take the same information and you rearrange it in a unique way or creative way, then you may be in a position to argue. That copyright claim, by the way, starts with the author, originator, or creator of the compilation. So you're first in a position to make the claim yourself. And the more ways you manage or compile or organize the data in a unique way, the better you're able to claim it as a compilation. I would say, though, succinctly, that a lot of databases have been set up for the data to be used specifically, and a lot of times you're probably going to be okay to say the database in its entirety is a compilation. But appreciate that even if the entire database is a copyrightable work, the individual data often isn't. So the individual record, name, address, etc., someone likes a particular product versus doesn't, that isn't copyright protectable. So that's where trade secret comes in. I think trade secret offers more protection than copyright, because one of the unfortunate aspects of copyright enforcement is you need to get a registration. And so although there are ways to file for copyright registration with trade secret coverage, still tends to not be a favored way to use your data because you don't want to disclose it even to the Library of Congress. So I would suggest that you look to trade secret a little bit more than copyright, although copyright is still relevant. Let's see, does it qualify as a sale if the vendor is using PL data in the vendor's possession to create anonymized data? Impossible to generalize there. And unfortunately, you're going to see differences on interpretation. And more unfortunately, I think a number of laws that are going to be taking effect have not been properly vetted to determine what certain words mean. So that's TBD, for better or worse. And probably going to have to look at it on a standardized basis. So I would still keep that in mind, but I don't think we can give an easy short answer right now that will work in all instances. And that will do it for us. I want to thank everyone for joining. Again, if you have follow-up questions, please respond back to our email. We will do our best to address them. Thank you, everybody.
Thank you.